is in relation to the same-sex marriage debate in the top court. We now understand a fresh affidavit has been filed by the centre before the Supreme Court. In this case, let's go across to our executive editor for legal affairs, Rhythm, also joining us. Rhythm, take us through this new affidavit that's been filed by the centre in the top court.
So let's tell you two breaking news that's coming in, Samiksha. One, the hearing on day 2 of the same-sex marriage case has begun before a constitutional bench of the top court. Second, the central government, after filing 2 earlier affidavits, has today filed another fresh affidavit before the Constitution bench, saying exactly what the Tushar Mehta, top law officer of the country, Solicitor General, said yesterday. They want state governments to be made a party in account since marriage is in the concurrent list. They've also said that states need to submit their views on same-sex marriage in case notice is not issued to them. Therefore, the union says states should submit their views in 10 days. Once this was stated in the Supreme Court, the court has said, all right, it's excellent, states already know about it. So they have stated this. However, inside the courtroom, there is a lot of, already in the morning, lots of action that started happening. We've got all the advocates making their first word placed before the Chief Justice of India and the Constitution bench. The Solicitor General, first I'll come across to the breaking news that we're actually beginning with. In a 5-page affidavit, the central government says that states need to be heard. They're also saying that the issue goes to the very root of the matter and therefore state needs to be heard. Now, I'm not going to go into too many details of what the central government is saying because that affidavit is broken. Let me also take our viewers towards what's happening in the courtroom. Already Mukul Rohatgi, appearing for the petitioner, says, I'm challenging the central law and saying that states need to be heard. Just because the subject is in the concurrent list does not mean states have to be joined. So preliminary arguments in the Supreme Court where already the petitioners are questioning the fact that states will also file their arguments before the court, and the Chief Justice says, let's not go into this, let's go back to your submissions. So possibly in a minute or two, Mukul Rohatgi, who wanted to finish his submissions from yesterday, will begin the submissions in the same-sex marriage case, after which we shall see what happens today during the hearing.
Rhythm, stay with us. Just a follow-up question. While we understand that the centre has said that all states should be heard in the case, we understand some of the states are already a party in this affidavit that's been filed in the top court. If you can take us through the finer details of that as well.
Well, states are not a party in this case yet because they've not been issued a notice yet. Okay. So what we're trying to say is today what's going to happen is that after this affidavit that's been filed where the central government is now asking for states and union territories across the country to be made a party to the ongoing proceedings, the court is going to consider this request of the central government.
All right, Rhythm, thank you for those details. So that's, of course, the latest coming in. Another affidavit that's been filed by the centre in the top court. This has been filed in relation to the same-sex marriage case. The centre has asked the top court to make all states and union territories across the country party to the ongoing proceedings, saying that the present issue falls within the legislative domain of the states. Let's cut straight across to the live streaming of the proceedings in the top court.
And give me something real. I have made a list of 4 or 5 items, Milord, as an example. Take, Milord, Payment of Gratuity Act. Other acts will provide pension. They provide, Milord, only to a spouse where the underlying thing that you are married. I am going to give you, Milord, some of them. One of them, Milord, is the... hold on. I'll give you, Milord. One of them is judge's pension. A judge's pension will go to a spouse. Now, a spouse presupposes that you have to be married. So if one of us, Milord, becomes a judge and then he gets a pension, tomorrow an issue will arise whether you are going, who will get the pension? Milord, for example, under the Income Tax Act, a gift is exempt from tax, Milord, as between members of a spouse which predetermines, Milord, a marriage. Now, if you're going to do that, how will that work, Milord? So there is a large number of acts. So the secular acts where, Milord, this issue doesn't arise of, Milord, personal laws. So the effect or declaration of marriage must flow to get us real rights where, Milord, these day-to-day things, at least in secular parts, are, Milord, involved. Motor Vehicles Act, Gratuity Act, Pension Act, Milord, Juvenile Justice Act, provides for, my lord, adoption. Says you can't adopt. As a living, you can't adopt unless you are married. So all those, my lord, those at least it must flow. Otherwise, what will happen? I'm sorry to use the phrase, I get a declaration, I get a badge. 5 years ago, I got that there will be no criminalization. After 5 years, I get this badge. Then, my lord, when I go somewhere, again those problems arise. They say, no, Supreme Court hasn't given you anything. Given you a badge of being married, fine. In society, you can go around and say, I am a couple who's married. But what is the real impact on the ground? Therefore, my lord, I have framed one or two reliefs, which I'll indicate. I'm only saying, my lord, idea should not be to go on revisiting the same issue from Puttu Swami and Navtej, back and forth. And we should only, at the end, if your lordships give me some, my lord, declarations, as and when in some other issues, something has to be fleshed out, it will come back to court. Nobody can, my lord, think of impossible.
Ring of litigations,
Yes.
incrementally as you call it.
Yes.
So rather than going at it whole hog.
Yes.
Whole hog you feel is a problem.
Yes.
Why is it a problem?
No. I am not saying it's a problem.
You don't want, because you don't want to open up the other fronts right now. You feel, what is the reason? You feel it's a distraction?
No, but I'm only saying, only personal laws. I'm only saying.
There is an organic hole in this.
Yes.
That's one point is,
Yes.
get a declaration, then you say that in some of these, what you term as secular, or
I term them as secular, non-personal.
so far so good.
Yes.
But when it comes to personal law, this will also implicate personal law, isn't it? Because some of your
Some of them will argue, my lord.
Yes.
Menka
now,
wants to argue.
Therefore,
You don't want. All right.
you may not argue. You have strategic reasons why you will not argue. But this court will have to engage itself once more, twice more, maybe 3 times or 4 times more.
Yes, absolutely right.
Each one of these.
Should not have.
The question is then we are not looking at it as a whole.
You have to look at it.
We are looking at it in a truncated manner,
Wants to give you.
which means that we, perforce, for the sake of, let's say, convenience or clarity, we say that we confine this declaration or whatever relief you are seeking to the Special Marriage Act, right? Which means that others who do not wish to or are not aware of this form of marriage, and I use these words very carefully, who are not aware of this form of marriage, of this going through the civil form of marriage, we can't presuppose, we can't assume that everyone knows this. They are denied this, right? Either they choose their religion or whatever. If they choose to, then they are out of this. So that is one aspect.
That is
Second aspect is they intersect with personal law even here. So keep that in mind when you make this.
yes, madam.
Yes. I'll get to later. Yes. I appreciate, my lord, for your lordship's comment. And I will. So now 469. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure the sexual and gender minorities' fulfillment of their fundamental right. It is imperative to confront the closet and, as the necessary consequence, confront compulsory heterosexuality. Confronting the closet will entail reclaiming markers of all desires, identities, and acts to challenge it. It also entail ensuring that individuals belonging to sexual minorities have the freedom to fully participate in public life, breaking the invisible barrier that heterosexuality imposes upon them. The choice of sexuality is at the core of privacy, but equally our constitutional jurisprudence must recognize that public assertion of identity found in sexual orientation is crucial to the exercise of freedom. But I submit 469 will fully apply. And instead of the words colonial legislation, we can use, beloved, the words colonial mindset. It is that mindset, beloved, which started from then. Society has evolved. Your lordships, beloved, struck down the barrier 5 years ago. But some parts of that mindset remain, which is evident from the stand of the respondents, including that of the states. And this mindset is, beloved, is implicit in the ground or at the ground level. Whenever we go to public spaces, and in the so-called, my lord, the secular laws which I'm mentioning, which also will have to be read in accord with the declaration, if your lordship so grant the declaration. In other words, I will propose at the end, but I will just preface. My lord, wherever husband and wife is used, make it gender neutral by using spouse. Wherever, my lord, man and woman is used, make it gender specific, gender neutral by saying, my lord, person. And I will give your lordship examples in the Special Marriage Act itself. So kindly, my lord, note this. Husband and wife should be used as spouse, and man and woman should be used as person. A large part of this, my lord, will solve our projected interpretation, my lord, of the Special Marriage Act. And what is good here must also apply across, my lord, the spectrum, at least of the acts, my lord, the examples of which I'm talking about. So that's why I said, my lord, 469 will fully apply by removing legislation into a mindset which is evident even today. Then, my lord, the lordship turns 471. 471 talked about reputable and disreputable sex. Kindly see, my lord, the last line of that page. If one accepts the proposition that public places are heteronormative and the same-sex sexual acts partially closeted, relegating homosexual acts into the private sphere would in effect reiterate the ambient heterosexism of the public space. Which means, my lord, in other words, the rule of majority in public spaces. It must be acknowledged that members belonging to sexual minorities are often subjected to harassment in public spaces. The right to sexual privacy, founded on the right of autonomy of a free individual, must capture the right of persons of the community to navigate public places on their own terms, free from state interference. What I'm really requesting, my lord, for a declaration of marriage is really a paraphrasing of this. When I walk into a public space, I walk into the public space with my partner, knowing that the law in the state recognizes this union as a marriage. Nobody will raise a finger of stigma against me. I walk into this public space. I walk into, my lord, public employment. I walk into private employment. I walk in, my lord, for pensions, gratuities, etc. That I am equal to the heterosexual group. And it's not that the heterosexual groups, my lord,